the population of Gaza is overwhelmingly composed of civilians, 98% civilian. And so to deploy this mode of deprivation against that population is to deploy it against the civilian population. And that's true even if one accepts the argument that the ultimate goal is to squeeze the combatants within that population into capitulation or submission.
How strong is the evidence that's out there to implicate Israeli leaders for the crime of starvation, in your view?
I think it's fairly clear that destructive conditions of life have been inflicted on Palestinians in Gaza. It's clear in terms of everything we've been discussing regarding the destruction of the agricultural system, the destruction of the water system, the impediment of humanitarian relief.
Welcome to this episode of Expert Witness. Today I'm joined by Professor Tom Dannenbaum, one of the world's leading experts on starvation in armed conflict, an associate professor of international law at the Fletcher School at Tufts University. He has written extensively on the legal, moral, and political dimensions of the crime of starvation in Gaza, Sudan, and elsewhere. We will talk about the evolution of starvation as a war crime, what's happening on the ground in Gaza, how international law defines and perhaps fails to enforce this crime, and whether recent developments at the International Criminal Court mark a turning point or just another chapter in impunity. Professor Tom Dannenbaum, it's a pleasure to have you with us today.
Thank you for having me.
Thank you. You've written extensively on the topic of starvation under international law. In your writings, you've described Israel's conduct in Gaza as a policy of deprivation. Given everything that's happened in Gaza since October of 2023, from intermittent aid access to a full siege, is it your legal assessment that Israel is using starvation as a weapon of war?
Yes, I think to reach that conclusion, it's helpful to understand a little bit about the law here. And the primary crime in question, prohibition under international humanitarian law, is the prohibition on starvation of civilians as a method of warfare. What that means is a combination of the deliberate deprivation of objects indispensable to survival, such as food, water, and other essentials, either for the purpose of denying those objects sustenance value to a civilian population, or in the knowledge that civilians will starve as a result of that deprivation. And I think if we look at the trajectory over time, there has, of course, been oscillation in the Israeli policy, and there has been a period, certainly during the first 6 weeks of the ceasefire at the beginning of 2025, where there was humanitarian access at a level where, at least during that specific period, starvation of civilians as a method of warfare wouldn't necessarily have been implicated. There are other periods, such as in the March to May of 2024 period, where there was relatively good humanitarian access compared to many of the other periods during this conflict. But certainly if we look at the initial stage following October 7th of 2023, and then after the Rafah offensive in May of 2024, and then again after the first 6 weeks of the ceasefire from March 2nd to the present, we can see multiple acts of deprivation of objects indispensable to survival. So most obviously that includes the impediment of humanitarian relief, but it also includes razing of agricultural land, destruction of water systems and medical infrastructure. That deprivation occurring in a context in which it was done for coercive reasons, in other words, to deny the sustenance value of those things, or alternatively in a context in which the food insecurity had reached a level at which it was clear that civilians would starve as a result of this deprivation, and it was deployed against a population that at the aggregate level is a civilian population. Even by United States intelligence estimates, the population of Gaza is overwhelmingly composed of civilians, 98% civilian. And so to deploy this mode of deprivation against that population is to deploy it against the civilian population. And that's true even if one accepts the argument that the ultimate goal is to squeeze the combatants within that population into capitulation or submission. That's not a relevant consideration when we're thinking about whether the acts of deprivation are deployed against a civilian population, and the population of Gaza, and also subsets of the population of Gaza, such as population of northern Gaza, which was the site of many of the most extreme forms of deprivation, have throughout been civilian populations when understood at the aggregate level.
And Tom, we've heard different descriptions of the situation in Gaza, from starvation to famine to catastrophic levels of hunger, for example, as used by the United Nations starvation monitoring mechanism. Can you please walk us through the differences between these terms and whether the situation in Gaza now falls under starvation, impending famine, and why the distinction matters?
It's important to distinguish these things, especially when we're thinking about the legal framework, because the legal framework is not contingent on an assessment of famine. That's a distinct assessment that is a technical threshold that's identified by the Integrated Food Security Phase Classification Mechanism and the Famine Review Committee within that process. And there they're looking for a combination of three specific metrics. So they're looking at whether or not there are 20% or more of households at catastrophic levels of food insecurity, meaning there are extreme food shortages for those households. They're really unable to gather adequate food, and they've exhausted all coping mechanisms in that respect. 30% of children in a situation of malnutrition, and then 2 out of 10,000 adults dying per day, or 4 out of 10,000 children dying per day as a result of the food insecurity in the situation at hand. So it needs to be a combination of those three things in order for there to be a famine declaration. And there are various reasons why those three might not all come in conjunction, or where it might be the case that it's difficult to gather sufficient data to assess whether one or more of those specific metrics has not been satisfied. So that's what they're looking for when determining whether there's a famine. And at multiple stages, in December of 2023, in March of 2024, and then most recently in the April-May period of 2025, the IPC assessment has identified high levels of risk of famine, or in certain cases, impending famine, in the most extreme case in March of 2024 in the report at that stage. But they've been assessing that risk based on the probability of those thresholds being breached. But when we're thinking about starvation as a concept in the legal domain, we're not specifically looking for that combination of three metrics. We're instead thinking about two possible forms of this concept. One is starvation as a process, and that's what I was referring to when I used the term depriving civilians of objects indispensable for their survival for the purpose of denying the sustenance value of those objects. That process of starvation, of starving people, the transitive concept of starvation, can occur before we're even close to those specific metrics that we'd be looking for in order to assess famine, because it's really about the process of denying objects indispensable to survival for their sustenance value. And that process can begin at a point at which there's not a high level of acute malnutrition yet, and there is not yet an elevated level of mortality. And yet the process of deprivation has begun, and if it's being done in order to deny the sustenance value of the objects that are deprived, the objects that are denied to the civilian population, then we're in the process of starvation. And so, in my view, for example, we can look back to the initial siege declaration by Yoav Gallant on October 9th, just a couple of days after the October 7th attacks, where he said no food, no water, no fuel, no electricity. And when he was specifically identifying especially food and water as objects that would be denied to the population of Gaza as a whole, which, as I already mentioned, is unambiguously a civilian population, there was no way to understand that other than as a deliberate effort to deny objects indispensable to survival, food and water, for the purpose of denying their sustenance value, because food and water, as food and water, simply are sustenance. And so at that stage, we can already identify a process of starvation. And the legal prohibition on starvation of civilians as a method of warfare attaches at that point, even though clearly at that very initial stage, we don't yet have elevated levels of acute malnutrition in children, elevated mortality, and 20% of households unable to access food. That takes time as stocks are depleted and so on. But the process began at that moment. The alternative form of starvation as an outcome, which also has legal significance, is more proximate to the famine threshold, but it's not determined by the famine threshold, which is itself applied at a population level and requiring the intersection of these three specific metrics. Starvation as an outcome in the law doesn't necessarily need to attach to all three of those. People can be starving at a level of fatal and near fatal acute malnutrition at levels that aren't quite at the percentages that would trigger a famine declaration, or without the other components of the famine declaration. And that would still implicate starvation of civilians as a method of warfare if it's known that those impacts will be arising for that population or for that subset of the population.
So at what point has starvation in Gaza during the course of this war become criminal, in your view?
Well, in my view, as I just suggested, I think it started right at the beginning of the total siege in October of 2023. And we saw really pretty severe acts of deprivation for the first 70 days, where for the first couple of weeks, there was no access at all. Then there was only a trickle of access through the Rafah crossing, and it was 70 days before any access was coming through any of the crossings in Israel. And even then, at significantly diminished levels compared to the need in Gaza, which is why we saw a really quick acceleration towards the famine thresholds that I just mentioned. And that continued, albeit with oscillating levels of access, through until at least March of 2024, where we did, into mid-March, see an uptick in access. But that really only lasted until May of 2024, when the Rafah offensive begins, and then we see again a diminishing access and a really severe diminution of access in northern Gaza into late 2024. And then again, there's a brief hiatus during the first 6 weeks of the ceasefire before we again see severe diminution of access to the point of no access for 78 days from March the 2nd until May of this year, and then a significantly reduced level of access subsequent to that. So all that's just to say that we've had various periods of starvation of civilians as a method of warfare attaching, but it began right at the beginning, because that's when the process of depriving the civilian population of Gaza of objects indispensable to its survival for the purpose of denying the sustenance value of those objects began. And that really began in the most explicit form in Yoav Gallant's declaration.
And Tom, you've mentioned that the population in Gaza is predominantly civilian, but Israel argues military necessity, and it also argues that Hamas or armed Palestinian groups are embedded within the civilian population. Are you saying that these arguments are unfounded?
Well, clearly there are combatants within the civilian population, members of the armed wing of Hamas and other militant groups in Gaza qualify as combatants, or at very minimum, persons directly participating in hostilities in the context of an armed conflict. But that doesn't transform the character of the population as a whole. We have both codified reasons for understanding this in Article 50, Paragraph 3 of Additional Protocol 1 of the Geneva Conventions, which articulates a principle that is also embedded in customary international humanitarian law, which is that the civilian character of a civilian population is not lost simply in virtue of the presence of combatants within that population. So as long as the population is predominantly civilian, then it retains civilian character as a population as a whole. And in the case of Gaza, it's not just predominantly, it's overwhelmingly composed of civilians. It's a tiny minority of the population as a whole that are combatants. And so the population doesn't lose its civilian character. We then need to understand, well, what does that mean in terms of the rules that apply to the conduct of Israel vis-a-vis the combatants in that civilian population? And the basic rule of international humanitarian law, which is codified in Article 48 of Additional Protocol 1, is that belligerent parties have an obligation in all of their military operations to distinguish between combatants and the civilian population and to direct those military operations exclusively and discreetly at the combatants and not at the population as a whole. And this is really very straightforward and not debated at all when we're thinking about kinetic attacks. So nobody argues that you can carpet bomb a population as a whole in order to kill the combatants within that population. That would be straightforwardly understood to be an attack on the civilian population that would therefore be a crime against humanity and indeed a war crime, even if it had this ultimate goal of killing the combatants within that population. And even if it were difficult to determine where exactly those combatants are, you can't attack the population as a means through which to attack the combatants. You have to discreetly identify and target the combatants, not the population as a whole. Where some push back against this principle is in the context of deprivation, and certainly that's the kind of argument that you're channeling that Israel has made, which is to say, well, on our view, the Israeli view, we can deprive the population as a whole of objects indispensable to survival if we're doing it for the reason of squeezing the combatants within that population. But this runs contrary to the basic rule of international humanitarian law that I just described. And it also runs contrary to an understanding of starvation of civilians as a method of warfare that is informed by that basic rule. So it's not that if Israel could specifically deny these objects to combatants in a way that was discreetly targeted at those combatants, that would be prohibited. That would at least plausibly be compliant with international humanitarian law. The problem is that they have been denying these objects to the population as a whole, or in certain contexts to specific subsets of that population, such as the population of northern Gaza in some of the most extreme forms of siege in that area of Gaza. And those actions were deployed against the civilian population. And because the civilian population doesn't lose its civilian character in virtue of the presence of combatants within it, we need to look at, was there intentional deprivation directed at that population, and not then seek to redescribe that intentional deprivation directed at a civilian population with a view to what the ultimate purpose of that deprivation was, because the ultimate purpose cannot rehabilitate the directed intentional action against the civilian population.
But Tom, listening to you now, I am getting the impression that international law is clear on the prohibition of starvation, that there is no exception to this prohibition. However, for example, Additional Protocol 1, Article 54 has long been criticized for allowing certain exceptions to that prohibition, for example, in paragraph 5 of the article. What's your take on that? Is the law unequivocal? Are there any loopholes that need to be rectified? Is that your interpretation of the law, or is it widely agreed that the prohibition has no such exception for military necessity?
Yeah, so there are two things to say about that. One is specific to 54 paragraph 5, and I'll address that in a second. The second is there any contestation around interpretation regarding this prohibition, both as a matter of underlying international humanitarian law and also as a matter of its implications for war crimes? Clearly, there's contestation on the interpretation. This is not a crime that has been prosecuted at the international level yet, so it's been codified for now almost 30 years, but we have not, for reasons primarily of jurisdiction and profile, seen a prosecution of this particular crime. So we don't have jurisprudence at the international level that clearly delineates some of the finer contours of the crime, and there therefore is space for some contestation around some of those issues. Although my view is that the fairly clearly stronger interpretation has to be compatible with the underlying principles of international humanitarian law, including in particular, as I said, the basic rule of international humanitarian law and the way that we should understand the meaning of a civilian population under international humanitarian law. So there's space for contestation there, and there is ongoing contestation there, but I don't think that that contestation can plausibly overcome those underlying principles of international humanitarian law, which are very clear cut. With respect to the specific issue of Article 54, subparagraph 5, that is unambiguously a loophole in the prohibition, at least in the codified prohibition in Additional Protocol 1. But it's actually a very narrow loophole to that prohibition because it is specifically associated with a so-called scorched earth policy. And what this entails is a belligerent party exclusively in an international armed conflict, in other words, a conflict between states, acting to destroy objects indispensable to survival, such as food, agricultural areas, water systems, on its own territory. So that's a key caveat here, on its own territory, upon the advance of the adversary into that territory as a military necessity to preclude that adversary's ability to reap the fruits of those objects indispensable to survival as it takes over that territory. So it's really about a very narrow military necessity. It's not a military necessity authorization overall that says wherever you see a military necessity, you can engage in the deprivation of objects indispensable to survival. It's specifically defensive. It's about defending one's own territory before that territory is occupied as a mechanism through which to preclude the advancing adversary upon its occupation of one's own territory, reaping the fruits of those objects indispensable to survival. And so it's a very narrow specification. My view would be that it would be better that that loophole weren't there, but it's also important to emphasize quite how narrow it is and that it's not available at all in non-international armed conflicts, and it's not available at all when a state is acting on another state or self-determining people's territory.
And Tom, I'm actually interested in hearing from you the history of this crime, because historically, siege warfare has been relatively permitted under international law or international state practice. So can you talk us through the history of siege warfare, and then at what point starvation has been regarded a violation of international law?
Yes, so it's clearly the case that siege warfare had been a part of war fighting for a long period of time, for many, many centuries, and that the law placed relatively limited, if any, prohibitions on that practice. And in fact, if we go back to the Liber Code of 1863, the codification of rules of warfighting that were drawn from customary international law but codified in a domestic US legal document by Francis Liber on the orders of Abraham Lincoln. In that particular code, which was then circulated widely internationally and drawn upon to understand international law, there is not only not a prohibition of starvation of civilians as a method of warfare, there's, in a sense, an encouragement of it in the language of the code to enhance or accelerate the submission of the enemy. So, in other words, pushing civilians back into a besieged area was permitted so as to accelerate the submission and capitulation of the adversary. So in that context, it was clearly seen as permitted. When we look at the Hague Regulations of 1899 and 1907, some of which drew upon the Liber Code, they don't go that far in terms of specifically encouraging the practice or explicitly authorizing it. But there's no prohibition on starvation of civilians as a method of warfare in those treaties, and those treaties don't include any specific regulation of the use of food or water or other essentials as weapons of war. When we get through to the Geneva Conventions in 1949, we start to see the beginnings of regulation of this particular method of warfare. both in Article 23 of Geneva Convention 4, with some significant loopholes and a very narrow focus on the populations that are protected, specifically focusing on children, maternity cases, and so on. But we do start to see a significant regulation of this issue in the specific context of belligerent occupation. So in particular, in Article 55 of Geneva Convention 4, supplemented by Article 56 and Article 59, we see obligations on an occupying power. In other words, a state that is controlling the territory of another state, now typically also understood to include the territory of a self-determining people, without the consent of that territorial state, the sovereign state or sovereign people, in a way that displaces the capacity of that sovereign state or self-determining people to control and exercise authority over that territory. In that context, where we have that external state exercising control without consent, then it has significantly heightened obligations regarding the food, medical, water, and other essential supply of the civilian population. It has a duty to ensure that supply. In other words, to not only not impede delivery, but actually to make sure that delivery of those objects indispensable to civilian survival reaches the civilian population, and that these systems are maintained in terms of medical systems, food systems, water systems, and so on. And even to bring those indispensable objects in from its own territory if the resources within the occupied territory aren't sufficient to provide adequate food, water, and medicines. But also where it can't do that, where it can't ensure adequate food supply, water supply, and medical supply, it has an obligation to allow unimpeded humanitarian access to that population so that that ultimate outcome can be realized. But that was very specifically for belligerent occupation. So there was relatively limited regulation of the use of starvation of civilians as a method of warfare and weaponization of food, water, and so on, outside of context of belligerent occupation, combined with a relatively heightened set of obligations for an occupying power within situations of occupation. It's only once we get to the 1977 additional protocols where this is then supplemented by a blanket prohibition on starvation of civilians as a method of warfare in both international and non-international armed conflicts, and regardless of whether or not the situation in question can be classified as a situation of belligerent occupation. But even in those 1977 conventions, the additional protocols to the Geneva Conventions, starvation of civilians as a method of warfare wasn't identified as a grave breach, which is the Geneva Convention language for a war crime. So it was prohibited, but it wasn't criminalized, at least not at the international level. And so it wasn't for another 20 years after that, when we get to 1998 and the Rome Statute to the International Criminal Court, where we first see a codification of starvation of civilians as a method of warfare, not only is prohibited under international humanitarian law, but also as a war crime. And rather extraordinarily, that was only for international armed conflicts. So there was a gap with respect to non-international armed conflicts, and it took another 20 years until 2019, where there was agreement on an amendment to the ICC statute to incorporate the war crime of starvation of civilians as a method of warfare for non-international armed conflicts as well as international armed conflicts, and that entered into force in 2021. So now, under the ICC framework and widely recognized as a matter of customary international law, starvation of civilians as a method of warfare is criminalized in all forms of armed conflict, and whether or not there's a situation of belligerent occupation. But the trajectory over time was such that the initial focus was on belligerent occupation. Even that really only arose as a significant set of obligations in 1949. It then took until 1977 before the prohibitions, and then another 20 years to get to 1998, and then 2019 with the explicit codified criminalization of starvation of civilians as a method of warfare across both armed conflicts, both forms of armed conflict.
That's very interesting. Tom, thanks for this historical overview. I know you're a leading expert on starvation, so I'm happy that we're taking advantage of this knowledge in this episode. But speaking of the Rome Statute and the prohibition of starvation with regards to non-international armed conflicts, you've mentioned that in your view, it's now considered as part of customary international law. What's the reasoning for that? How is it part of customary international law? Because customary international law reflects state practice and their official legal positions. However, very few states have actually signed up to this amendment in the Rome Statute. But I know that the International Committee of the Red Cross also agrees with your view and actually considers the prohibition on starvation as customary international law, both with respect to international armed conflicts and non-international armed conflicts. So on what basis is it custom, in your view?
So there are a few things we can look at, and it's perhaps worth distinguishing the underlying international humanitarian law rule from the war crimes. So if we're looking at the underlying international humanitarian law rule, the prohibition on starvation of civilians as a method of warfare applies in non-international armed conflicts as a codified matter in Additional Protocol 2, which has 169 states party to it. So the overwhelming majority of states are party to that specific treaty that does prohibit this specific act. But that's as a matter of the IHL prohibition. And the question is, A, does that then extend to that being a customary prohibition? And B, in particular, does it extend to it being a war crime under customary international humanitarian law? And there are a few different things that we can identify in this respect. The first is that when the negotiations around the amendment that ultimately was agreed in 2019 and entered into force a couple of years later at the ICC statute were taking place, those negotiations and discussions were predicated on the understanding of the states involved that this was a customary international law crime. In other words, while they were engaged in incorporating this into the ICC statute, they were doing so identifying it as a codification of existing customs. So that itself is significant opinio juris, because even though the number of states that have actually ratified the amendment remains relatively small, and that will, of course, increase over time, and it takes long for many states to ratify treaties for various reasons, primarily of domestic process. The states parties to the ICC statute by consensus agreed on the incorporation of this amendment into the ICC statute. So they recognized the importance of incorporating this into the ICC statute, and that recognition was predicated on an understanding of this as prohibited in customary international law. We can see this prohibition manifest in many states' military manuals and domestic war crimes codes, which are themselves also reflective of opinio juris, and that can underpin an understanding of customary international humanitarian law here. Also, notably in Resolution 2417, a landmark Security Council resolution in 2018, which was focused on starvation of civilians as a method of warfare and brought it to the core of the Security Council's protection of civilians mandate, they look at starvation of civilians as a method of warfare as prohibited, not just as a matter of treaty law, but as a matter of customary international law, notably the United States, which is not party to either additional protocols and which is very willing to take stances contrary to the additional protocols as a matter of customary international law where it deems doing so to be appropriate, was a voting member in the Security Council, has a veto in the Security Council, and yet supported Resolution 2417. And Resolution 2417 also calls for the investigation and, where appropriate, prosecution of starvation of civilians as a method of warfare, the pursuit of accountability, recognizing that it can qualify as a war crime. So that itself is another key component of state practice in opinio juris. And starvation of civilians is, and that's not contingent on the classification of armed conflict in Resolution 2417. And then there are other manifestations too. For example, the Malabo Protocol within the African Union, which has not yet achieved a sufficient number of ratifications to enter into force, but was agreed as a matter of the treaty through the African Union system, includes starvation of civilians as a method of warfare as a war crime in both international and non-international armed conflicts. So all of those different features support the view that this is a customary international law prohibition and that it has war crime status under customary international law, even though we have no international level prosecutions of this crime yet. And one way of thinking about customary international law in these kinds of contexts is that when something's prohibited, the state practice we would expect to see would be refraining from that conduct and then condemning that conduct when it is performed by other actors in the system. And we have seen, especially since Resolution 2417, but also going back before that, in some ways informing that bringing of starvation of civilians as a method of warfare to the center of the protection of civilians mandate within the UN system, condemnation of starvation methods across various different situations and through various different methods, whether it is siege tactics in Syria, whether it's blockade in Yemen, whether it's deprivation in various manifestations, including attacks on agricultural systems and food in Sudan or indeed in South Sudan. We've seen that kind of condemnation. And so that condemnation, combined with most states refraining from engaging in this practice, is also indicative of customary international law status.
But why then has it been rarely litigated, in your view?
There are two key reasons, I think, why we've seen very few starvation prosecutions at the international level. The first is that through some of the tribunals, the ad hoc tribunals for Rwanda and former Yugoslavia that existed prior to the International Criminal Court, there wasn't yet a sense that this was unambiguously criminalized as a matter of international law. So that ICC codification in 1998 was really crucial to providing a focal point for understanding this as a war crime. And the fact that it wasn't included as a grave breach in the additional protocols undermined the viability of invoking it as a war crime at the ICTY, for example, the International Criminal Tribunal for the former Yugoslavia. The second issue, though, is that once we get to the International Criminal Court, as I said, in 1998, the codification is exclusively for international armed conflicts. It seems from the drafting history that this may simply have been an administrative error, that they were deleting certain provisions of non-international armed conflict, war crimes that had generated some controversy, and starvation of civilians as a method of warfare happened to be, just as a matter of its spatial positioning, in the group of crimes that were being removed, even though it specifically does not seem to have generated much controversy. So it was almost thrown out with the bathwater rather than specifically identified as something that hadn't reached customary international law status. But the consequence is that it was not in the ICC statute at the time of the ICC's creation in 2002, following that 1998 Rome Statute agreement. And so that means that it was only available for international armed conflicts for most of the ICC's duration. And even once we get the non-international armed conflict amendment in 2019, it still wasn't available for non-international armed conflicts, except where the state in question had ratified that specific amendment. And as you mentioned, we're still waiting for that number to rise to a significant level. And the key problem is that the states where starvation of civilians as a method of warfare has most plausibly taken place have not ratified that amendment, or are not even ICC state parties to begin with. And so there's not ICC jurisdiction over those states. So, for example, the ICC does not have jurisdiction in the context of Yemen, doesn't have jurisdiction territorially over Yemen, doesn't have jurisdiction with respect to the Saudi-led coalition in terms of their actions in the conflict in Yemen. And so there's not ICC jurisdiction in Yemen, regardless of conflict classification issues. There's not jurisdiction because the states aren't state parties to the ICC. Same thing with Syria. And so we have a number of situations where this crime plausibly took place, and yet we don't have jurisdiction at the ICC. And then the final reason is that precisely because it hadn't been prosecuted, and precisely because there are some ambiguities around, therefore, where exactly the criminal law threshold would attach, and because it looks different from many other kinds of war crime, which are more immediate in terms of the consequences of the Prohibited Act. So when somebody shoots a prisoner of war, it's very straightforward to identify the crime, and the only question is which individuals, apart from the physical perpetrator, are potentially liable for it. Whereas with starvation of civilians as a method of warfare, because we have the Prohibited Act and then a stretched temporal context in terms of the impact of that act and the way in which multiple different factors are intervening on that impact, there's more of a reticence on the part of prosecutors in the absence of pre-existing jurisprudence, and given that specific structure of the practice, to pursue criminal accountability in those cases because there's more uncertainty from a prosecutorial perspective regarding exactly what you need to do to show that the legal threshold has been met and how best to do that. To a certain extent, those uncertainties have been mitigated by the fact of the ICC codification and the codification of elements of the crimes within the ICC system. But at least prior to that, the combination of uncertainty regarding whether this was a crime at all, and then uncertainty regarding how to prosecute it, how to understand the structure of the process themselves led to prosecutorial reticence. And so it was largely because prosecutors weren't bringing those cases rather than necessarily because courts would have rejected them that we didn't see them arising. And so that's in many ways why the arrest warrants for Benjamin Netanyahu and for Yoav Gallant are so significant, because this would be a landmark, already in a sense is a landmark just in terms of the arrest warrants being issued. But the further we get down that process would be increasingly a jurisprudential landmark in terms of laying out the foundations upon which prosecutors in other cases could then build, and from which they could gain confidence in terms of pursuing this particular criminal wrong.
So is it the first time that the crime is litigated before the ICC?
Yes. Yeah. So this would be the first prosecution of starvation of civilians as method of warfare at the ICC. And that's largely at the ICC because of the fact that most situations in which this crime has been implicated during the existence of the ICC are either entirely outside of ICC jurisdiction because they involve states not party to the ICC system, or are situations of non-international armed conflict where the ICC doesn't have jurisdiction over the war crime of starvation of civilians as a method of warfare, specifically because the criminal acts either occurred before the entry into force of the amendment in 2021 or involve states that have not ratified that amendment, and in most cases, both of those things.
How strong does the evidence need to be for the ICC's pretrial chamber judges to confirm the arrest warrants? From your knowledge of this case, what standard have they been working with?
Right. So when we look at specific cases, in other words, cases against identified individuals for specific crimes, there are three different thresholds of evidence that the ICC uses. The first is at the level of confirming arrest warrants, of issuing arrest warrants, which are issued by the pretrial chamber on the application of the prosecutor. And there the threshold is reasonable grounds to believe. So that's less than more likely than not, but it does mean that there needs to be evidence that indicates to a reasonable person that this individual may have committed that crime. It's not a mere suspicion, but it's also not a threshold that says it's more likely than not that they committed that crime. There have to be reasonable grounds to believe that that person committed that crime. The next stage would be the confirmation of charges, which is again at the pretrial chamber level. This would ordinarily occur in the presence of the accused, although we've recently had jurisprudence at the ICC in the case of Joseph Kony, where there can be confirmation of charges in the absence of the accused. There still can't be the trial of the case without the accused, but this is about the confirmation of charges. And the confirmation of charges threshold is substantial grounds to believe. So it's higher than reasonable grounds to believe, but we're still not yet at the level of beyond reasonable doubt. Beyond reasonable doubt then is the threshold that's used when we're finding a criminal conviction after the trial. So there's this gradual increase in the epistemic threshold that the court is applying to determine whether we move forward at each stage. Is an arrest warrant issued? It's about, are there reasonable grounds to believe? Next step, are we going to confirm the charges? Well, are there substantial grounds to believe, again, that this specific person perpetrated these specific crimes? And then finally, once we get to the full trial, then it's beyond reasonable doubt. So it's an escalation over time.
And what's your expectation? I know that the trial will only start if if those wanted by the court are actually arrested and in The Hague. But how strong is the evidence that's out there to implicate Israeli leaders for the crime of starvation, in your view?
Well, I think for that specific crime, the evidence is quite strong. And a key factor here is, and I didn't mention this earlier, but it was implicit in my comments, that starvation of civilians as a method of warfare doesn't have a specific consequence element. So you don't have to show that the acts in question caused a specific outcome. You have to show that the deprivation occurred with the requisite intent being either that there was a purpose of denying the sustenance value of the objects that were deprived to a civilian population, or, although this is more open to debate, that the perpetrators knew that starvations would starve as a result. But even in those contexts, you don't have to show that this actually caused a specific outcome in terms of, for example, a specific number of fatalities. So really the evidence has to be about, did this specific set of acts of deprivation occur, and did they occur either for the purpose of denying sustenance value of the deprived objects to a civilian population, or knowing that civilians will starve as a result of that deprivation. And here we clearly have the acts of deprivation. There's really no ambiguity that there has been impediment of humanitarian relief, there's been razing of agricultural lands, there's been destruction of water systems, there's been denial of electricity necessary for water desalination, a whole host of acts of deprivation. And so then the only real question, the only open question, is question of intent. But as I mentioned, we've had various statements, most obviously the initial statement by Yoav Gallant at the beginning, but also statements when we look at the renewed total siege from March 2nd onwards after the breakdown of the ceasefire, where those statements are unambiguous that this is being done to deny the objects as food or as water or as medicine. In other words, to deny them for their sustenance value, not because they serve some other purpose than sustenance, but specifically for their status as food or as water or as medicine. And so those acts of deprivation, combined with the statements that explicitly articulate a policy of sustenance denial, in my view, are very strong evidence of this particular criminal act. And then if we want to look at the alternative mode of thinking about intent here, oblique intent, knowing that starvation will occur as a virtual certainty, certainly once we start to get the stark warnings from the IPC in December of 2023, and then again in March of 2024, and then again recently in May of 2025, each of these stages themselves provides really powerful evidence that this is going to cause starvation with a virtual certainty. And this includes the continuation of acts of deprivation after reports of children dying from malnutrition and extreme levels of hunger in the Gaza Strip. So all of these in combination, I think, provide very robust support to the case for starvation of civilians as a method of warfare in this context. And that's all, of course, supplemented by the potential testimony and certainly the public statements of humanitarian organizations, because those humanitarian organizations are also important in understanding what forms of deprivation are occurring, what forms of impediment are occurring, and what possible explanations are there for those impediments. And could any of those explanations for the impediments to the delivery of humanitarian relief indicate something other than a policy of sustenance denial? And so there, the testimony of humanitarian organizations would be potentially critical. And also, I think, critical on the point about the possible diversion of humanitarian relief, because for the reasons I mentioned earlier, you can't deny humanitarian relief to a civilian population for the purpose of denying it to combatants. So the only way in which diversion to combatants would be in any way relevant would be if the aid was systematically and almost entirely being diverted to combatants and not reaching civilians at all, such that impeding that delivery wasn't impeding delivery to civilians because it wasn't going to reach them, but instead impeding delivery to combatants. But humanitarian organizations have consistently said that there has not been significant at-scale diversion away from civilians. And we saw during the ceasefire that there was significant delivery to civilians. And so there again, that testimony and that information would be important in rebutting any counter-arguments regarding diversion and its significance for the criminal case.
And Tom, what do you make of the Gaza Humanitarian Foundation? Would you consider it part of the use of starvation as a weapon of war? Some have described it as an instrument of forced displacement as well. But for the sake of our discussion, what's your assessment of it legally, and does it fall under the crime of starvation?
So often we can have intersecting crimes, and starvation and forced transfer, or in some cases forcible deportation. Here we're mostly looking at forcible transfer within Gaza, but from one area to another. Those two crimes can intersect and can be mutually exacerbating. And certainly when we look at Israel's new plan regarding humanitarian delivery and the Gaza Humanitarian Foundation, it looks as though it is both not diminishing the concerns about humanitarian access sufficiently to reverse or to cease starvation of civilians as a method of warfare. So in some ways, it's of course better than the total siege that we had for 78 days prior to the implementation of this plan, but it's still nowhere near what's needed. And so it looks like a continuation of starvation of civilians as a method of warfare. But it certainly also looks as though it's using access to food and access to sustenance as a mechanism through which to forcibly transfer populations. So there's an exacerbating and additional intersecting crime associated with that. But going back to your initial question, how does this intersect specifically with starvation of civilians as a method of warfare? There are a number of components of the plan that are relevant to that. The first is the significant diminution of the number of aid distribution points from hundreds to single digits in terms of the number of aid distribution points, which of course means that there are many civilians that are not going to be able to reach those distribution points at all, and so aren't being served by this delivery mechanism, as opposed to a system of humanitarian distribution that the humanitarian organizations were undertaking, especially during the ceasefire, that was much more comprehensive in terms of its reach. But it also obviously creates significant insecurity for the civilians that are able to access these mechanisms, both in terms of creating crowds of people acting in context of desperation to try and access food, which creates insecurity in those zones and has led to killings of civilians seeking to access humanitarian access, but also in terms of their travel to and from these aid distribution points, in terms of the insecurity of having to travel through conflict zones in order to access humanitarian aid, and then returning with the aid packages that they've received in context of manufactured scarcity, where of course those packages are of extreme value and are therefore likely to make individuals targets. So there are many ways in which this specific system is designed in a way that exacerbates the insecurity of civilians, doesn't reach a sufficient number of civilians, is even by Israel's own estimates not going to deliver sufficient aid to supply the population as a whole, and therefore looks as though it is a continuation in a less blatant form than the total siege that had preceded it of starvation of civilians as a method of warfare. And here, even if we thought there was some ambiguity about whether this is being done for the purpose of sustenance denial, in other words, these various flaws are purposed towards sustenance denial, it's clearly being done in a context in which there is a virtual certainty that civilians will starve as a result of this, given that the IPC Famine Review Committee had just affirmed that there is a high risk of famine across the Gaza Strip as a whole, and we have 244,000 civilians in Gaza, even by the most recent estimate, at catastrophic levels of food insecurity. And so this is occurring, again, in a context in which the deprivation has the virtual certainty of causing starvation in the civilian population.
And we've seen disturbing reports of many shootings near or at aid convoys or at distribution points related to the Gaza Humanitarian Foundation. In your view, how do such incidents intersect with the legal prohibition on starvation, or generally speaking, under IHL, who is responsible for these incidents before international law?
Well, one of the other crimes within war crimes within the ICC statute is directing attacks at civilian population or directing attacks at civilians. And indeed, that is a component of the arrest warrant for Benjamin Netanyahu and Yoav Gallant. And in those specific arrest warrants, it was in particular attacks at civilians, attacks directed at civilians in the context of aid distribution. We don't know exactly which attacks were the attacks that underpinned the finding of the pretrial chamber in issuing the arrest warrants in November of 2024. But we do know that they identified two attacks on civilians or civilian populations as part of this overarching policy of food deprivation and denial of humanitarian access. And so those attacks on civilian population were at either humanitarian distribution points or possibly at humanitarian actors themselves or otherwise associated with this issue. So that was, of course, all prior to the current situation, but it's just to say that those crimes and their connection to starvation of civilians as a method of warfare is already part of the case against Gallant and Netanyahu. This more recent spate of killings at aid distribution under the new plan following the ending of the total siege is also a set of killings that are related to starvation of civilians as a method of warfare and therefore could be charged both as attacks directed at civilians as an independent freestanding war crime, but with a connection to this overarching policy, but also potentially additionally as part of the deprivation of objects indispensable to survival. That would be slightly harder because we'd need to show that these attacks were themselves part of the policy of deprivation. Otherwise, they were done to deny access to sustenance, and that would be evidentiarily more complicated. But clearly, they're part of this overarching framework. Clearly, they're undermining civilian access to humanitarian aid, and so plausibly, they could be incorporated into the starvation charge itself. But regardless of that, attacks on civilians are straightforwardly war crimes on their own terms. And so merely being part of a civilian population that is in a context of panic, moving in various ways that then lead to these attacks is not a sufficient basis for the attacks being perpetrated. And so those attacks will plausibly be subject to investigation and possibly charges as attacks directed at the civilian population or at civilians.
And Tom, you've mentioned that starvation often occurs or can occur alongside other crimes. I'd like specifically to hear your view on the overlap between the crime of starvation and genocide. Under the Genocide Convention, obviously, one of the acts is the deliberately inflicting conditions of life calculated to bring about a group's destruction. So where does starvation fit into that clause? And does Gaza meet the threshold of genocide, in your view?
So I think when we're thinking about conditions of life, destructive conditions of life, it's important to emphasize that they can qualify as a crime against humanity, particularly the crime against humanity of extermination, where those destructive conditions of life lead to death, and also potentially as an inhumane act, another inhumane act, as a crime against humanity, and also where there's discriminatory intent, also potentially persecution as a crime against humanity. So there's an intersection across the war crime of starvation of civilians as a method of warfare, crimes against humanity across various different subcategories of crime against humanity, each of which can be implicated by the impacting of a civilian population through destructive conditions of life, and then conditions of life, destructive conditions of life as an underlying act of genocide. So all three of these categories, war crimes, crimes against humanity, and genocide, can be implicated by starvation methods. And in the category of crimes against humanity and genocide, this concept of destructive conditions of life is the central modality through which starvation would be incorporated into those criminal categories. So there are, of course, other criminal categories in genocide, killing, infliction of serious bodily harm, mental harm. Those could also be implicated by starvation methods, but the most obvious one is conditions of life calculated to bring about the destruction of the group. I think it's fairly clear that destructive conditions of life have been inflicted on Palestinians in Gaza. It's clear in terms of everything we've been discussing regarding the destruction of the agricultural system, the destruction of the water system, the impediment of humanitarian relief. But it's also clear in terms of the destruction of the medical system and infrastructure, the destruction of the residential system, of homes, displacement of the population. The entire conduct of this campaign has been conduct that has inflicted conditions of life that are destructive for the Palestinian population in Gaza. In my view, that clearly meets the threshold of starvation of civilians as a method of warfare, as a war crime, and clearly also implicates various crimes against humanity, most obviously other inhumane acts, potentially persecution, and on the ICC's assessment, and it admittedly looking at this at an earlier stage of the conflict, so in evidence up to May of 2024, a year prior to our discussion right now, they found the infliction of conditions of life calculated to destroy civilian population to be present, which was the basis for their determination that an arrest, or at least that there were reasonable grounds to believe they were present, which was the basis for their issuing of an arrest warrant for the crime against humanity of murder for Netanyahu and Gallant. So that's just to say that the destruction of conditions of life, the destructive conditions of life component to this is, I think, relatively clear-cut. It's also relatively clear-cut that Palestinians are a national group that therefore have protected status under the Genocide Convention, and that the Palestinians of Gaza, as a part of the national group of Palestinians as a whole, is a part of the group that is sufficiently substantial and important to that group such that an attack aimed at destroying that part of the group would qualify as having the genocidal intent necessary to implicate genocide against Palestinians as a national group. Those things are all relatively clear-cut. So the only thing that's really in question in determining genocide or not is determining genocidal intent. And that's the specific intent, the specific purpose to destroy this specific part of the Palestinian national group, namely the Palestinians of Gaza. And that purpose can coexist with other purposes, so it doesn't need to be the exclusive purpose. It could be instrumental to other purposes, and it could also be existing, notwithstanding that it's not fully implemented or implemented to its most extreme or efficient form, because there are constraints on the ability of the actor in question to pursue that intent without external constraining forces. So, in other words, to keep, for example, the United States on board, there may be an imperative not to pursue a particular criminal purpose to its maximum extent, so as to leave some kind of plausible deniability that then reduces the amount of external scrutiny and pressure. All of those things are clearly compatible with genocidal intent. But ultimately, when you're trying to determine whether genocidal intent exists or not, we're looking at what the purpose of the conduct was. And so the conduct, which clearly implicates crimes against humanity and starvation of civilians as a method of warfare, will or will not implicate genocide depending on the purpose for which it was performed. In my view, the question of the distinction between genocide, crimes against humanity, and war crimes is primarily important, not for the ultimate determination, where at least crimes against humanity and genocide are equally grave, generate equally grave consequences in terms of sentences, and should generate equally grave condemnation, but instead because of a specific component of genocide, which is that it entails a clear duty to prevent under Article 1 of the Genocide Convention. So the duty to prevent genocide within the Genocide Convention itself is the thing about genocide that is most important in distinguishing it from crimes against humanity and war crimes. And whether or not courts ultimately reach the determination that that purposive intent that's constitutive of genocide has been present in this particular campaign, and I think there are reasons they may or may not reach that determination. think that is an open question in terms of where courts will land on that, given that purpose is often difficult to discern. What is unambiguously the case, in my view, is that the duty to prevent genocide has been implicated, because that duty occurs when there is knowledge, or where there should be knowledge, of a serious danger of genocide occurring. And there's no ambiguity at all that that threshold has been breached, because we have destructive conditions of life that have actually been implemented against a protected group. And the ICJ has 3 times, through provisional measures, determined that there is a real risk to the rights of the Palestinians under the Genocide Convention, implicated in the way that Israel has conducted this campaign, in particular with reference to impediments to humanitarian relief. And that real risk, which was the basis for the ICJ issuing provisional measures orders, is itself related to the serious danger that implicates the preventive duties of third states vis-a-vis Israel in terms of preventing genocide from occurring. And so this is obviously a very long-winded answer, but the ultimate upshot of it is that I think the preventive duty vis-a-vis genocide is clearly implicated here, because we have destructive conditions of life that generate a serious danger of genocide. And with respect to whether we can discern that the conditions of life have been inflicted with the purpose specifically of destroying the Palestinian group, I think is something that is less obvious, but there is significant evidence that weighs in favor of that determination. And I think it's an open question whether courts will reach that determination ultimately. But I think at the current moment, the most important thing is whether or not the preventive duty vis-a-vis genocide has been implicated. And I think that's clear.
And Tom, given the intersection between the starvation crime and other crimes, as you have discussed, you've also addressed what you describe as starvation as a form of societal torture. You've described this in a number of your legal academic papers. So could you explain to us what led you to this conclusion, and how does that description relate to the situation in Gaza right now? And why is it important legally and morally to frame it this way?
Yes, so the reason for framing starvation as societal torture isn't so much to specifically classify it as torture per se, but rather to understand the underlying wrong that underpins the criminality of starvation methods. In other words, to understand why it is that this thing is a distinctive crime as compared to attacks on civilians or other kinds of crimes. And the motivation for framing it in those terms was responding to a particular kind of distortion that I identified in terms of how people were framing starvation as either a lesser offense or as more easily pushed back against in terms of particular conduct not qualifying for the criminal threshold. And in particular, it goes back to the discussion I was raising earlier with respect to how to understand a civilian population and how to understand the basic rule of international humanitarian law, which is that you can't direct military operations at a civilian population. They have to be directed discreetly at combatants. And so this is straightforward when we think about, and straightforwardly accepted when we think about kinetic attacks. So it's widely accepted you can't carpet bomb a civilian population in order to kill combatants within that population. You have to specifically target the combatants or the military objectives. And yet when we talk about starvation, often the pushback, and you already mentioned this in terms of the way that Israel has articulated its position in this conflict at various moments, is, well, we're not trying to starve the civilian population. We're trying to starve the combatants or squeeze the combatants within that population. It's just that the only way we can do that is by cutting off the population as a whole. But we don't accept that when it comes to kinetic attack. And so partly I was writing this piece to say, well, why would we accept it with respect to deprivation? And the one argument that you will often get in response is, well, deprivation is more gradual. So we're not actually trying to cause civilians to starve to death. We're trying to squeeze the combatants so far that they capitulate, and therefore that we avoid starvation of the civilian population. And this paper was written to say, but the process between the acts of deprivation and that capitulation isn't a benign process. It's not that if we don't reach the point at which civilians are starving to death, there's no wrong. The wrong is, in fact, in the process as a whole, because what occurs in that process is, first of all, precisely an effort to break the will of the population to sustain resistance in a particular context. Doing so in a context in which it's known that combatants will be the last to starve. If there's a situation of manufactured scarcity, those with the guns are going to be the last ones to starve to death, because once we reach the point at which people are desperate, people with power are going to use that power to access whatever limited resources are left. And so what's happening to the civilian population in that process? They are being denied an essential biological imperative, sustenance, in a context in which the denial of that tears against their capacity to sustain higher order commitments to one another, to their loved ones, to their society, to their political community. In other words, there's a deliberate effort to break their will, and there's a known foreseeable consequence of that rupturing the will. And we see across famines that what's called the accordion effect occurs, where the web of social concern contracts, where social bonds start to rupture, and where society is essentially torn apart by the fact that people's biological imperative to be free from the suffering associated with hunger is tearing against their higher order commitments, including commitments for which they would sacrifice everything. And all of that is reminiscent of what happens with torture. And we don't think, well, torture's not as bad as killing because the person's not killed at the end. Instead, we think torture is one of the most morally condemnable acts and one of the most clearly legally prohibited acts, because it has this particular dehumanizing impact of tearing people against their higher order commitments. The whole point of inflicting severe pain in the context and suffering in the context of torture is to force people to do something they don't want to do, or to punish them in a way that turns their body against their soul, against their will. And all of that is, at a societal level, what happens when we see mass starvation mechanisms, when we see deprivation across a population as a whole. And so the paper was primarily written to push back against the notion that the graduality of starvation methods as compared to kinetic attack in some way mitigates their wrongfulness, and to instead argue that that graduality is constitutive of a distinctive wrongfulness, namely a torturous wrongfulness that is itself condemnable at the highest level of criminal prohibition. And in terms of its manifestation in particular contexts, it's not surprising that we see desperation, that we see looting, that we see society rupturing in contexts in which there is a manufactured deprivation of objects indispensable to survival. That's what we see across famine contexts. And so it's not in some way indicative that the besieging party was correct, that this aid isn't going to access civilians in an orderly and straightforward way. It's instead a consequence of having inflicted total desperation on a population through depriving them of objects indispensable to their survival. So it's a manifestation of precisely the kind of social rupturing that is constitutive of the wrongfulness of starvation methods in the first place.
And Tom, as we're approaching the end of this conversation, I would like to hear from you on what reforms are needed with regards to the prohibition of the crime of starvation under international law. You've addressed this throughout the interview, but I would like to hear specific thoughts from you on what needs to be done to rectify any loopholes within the law or the jurisprudence.
I think there are several things. One is that in the immediate term, we need to see significant ratification of the amendment to the International Criminal Court statute for starvation of civilians as a method of warfare in non-international armed conflicts. So it's one thing for the codification now to be parallel across conflict classifications, but it's another thing for ratification to reach a level where there's jurisdictional parity across those two. So that's the first thing, is just ratification of that specific amendment, and similarly incorporation into domestic criminal codes. A second component would be to explicitly articulate starvation methods as a crime against humanity. So I mentioned earlier that it implicates many crimes against humanity: extermination, murder, inhumane acts, and persecution. But extermination and murder only attach in the context of lethal outcomes. And so they're inadequate to properly capture the full wrong that I just identified and discussed in framing this as societal torture, they only capture the ending of that, the fatal ending of a starvation policy. Persecution and inhumane acts can capture the wrong across its full life cycle, but persecution only attaches in contexts in which that's inflicted with a particular discriminatory animus. So it leaves out certain kinds of cases where you can't identify that discriminatory animus. And so that's inadequate. And inhumane acts, although they can capture this, are a capacious residual category. So they don't really specify starvation and identify it with the kind of clarity and specificity that would be optimal. And so there's now an opportunity, because there is the opening of the negotiation of a Crimes Against Humanity treaty, to, in that treaty, include a specific subcategory of crimes against humanity, that is the starvation subcategory, that would be derived from its status as an inhumane act, but specified in particular for that specific wrong and in a way that captures the wrong across its entire form. And then the final thing is for elevated attention to this, and elevated attention to it across situations and across contexts in which it's deployed. So Gaza has drawn attention to this particular crime in a way that it had not previously received. So it hadn't received this kind of attention across the many other situations in which it's been deployed. The key thing now is to, first of all, of course, continue to pressure for preventive mechanisms and for accountability in that specific context, but also then to build upon the recognition of the wrongfulness of this practice and the public salience that it has gained in this particular context, to push for accountability and prevention across other situations, whether it's Sudan, South Sudan, Yemen, or otherwise. So thinking about the various contexts in which this is being deployed, and thinking about the imperative to pursue accountability for past wrongs in that sense, and also to pursue prevention for ongoing wrongful violations in this particular context. And so it's partly about normalizing the sense of this as a crime, as opposed to thinking about it as something other than that, and then deploying that understanding to pursue accountability and prevention across situations.
And Tom, last question. To what extent do you view international criminal law and international legal frameworks in general as an appropriate mechanism of responding to famine-related crimes or situations around the world, but particularly in Gaza? And alongside the legal framework, what else needs to be done, in your opinion?
So clearly it can't be the only mechanism, because international criminal law and criminal accountability is ex post. It comes at the end. It comes pursuant to a full evaluation of evidence, to the beyond reasonable doubt threshold. And all of those things mean that it is not adequate to actually preventing the wrongs while they're occurring. It's more about accountability after the fact. That's an important component of international law, but it's not the only component. A key component of international law is real-time impact. And that means real-time impact in terms of norm internalization and action guidance within the agents of warfare in a particular context. So that's about really internalizing this within the military training of militaries across the system, so that this is seen as something that they simply will not do. But also, significantly, where that's not working, where the actor in question is willing to violate these rules, third parties placing pressure on that state or other belligerent to cease engaging in those wrongful acts. And that means ceasing to supply arms, ceasing to supply political cover and other support for wrongful activity. And that is more about underlying international humanitarian law, and also preventive duties such as the preventive duty regarding genocide that I mentioned earlier, which is why I think that specific component relating to genocide is actually the most important right now, because it's something that we can determine and indeed are required to determine in real time. It's not something that we leave for ex post accountability and a careful evaluation of exactly what form of purpose was manifest in a particular context. We can identify a real risk now based on destructive conditions of life deployed against a group that's protected under the Genocide Convention, and therefore demand preventive action now. So that's still using law, still using legal mechanisms, but not in the form of criminal accountability, but instead in form of real-time evaluation and deploying political leverage and other forms of leverage to prevent these wrongs from occurring. And that can be done either through international humanitarian law, the duty to ensure respect for international humanitarian law in Common Article 1, or through the Genocide Convention itself.
Well, that was very insightful. Thanks a lot, Tom, for your time. I really appreciate it.
Thank you. Thanks for having me.